Okay, thank you to everyone for coming today for the Board of Advocates Trial Advocacy Committee training. We are very, very fortunate to have with us today Mr. Steven Laird, who is a longtime friend of this law school. For those of you who don't know, our Justice Center downstairs, where several of you spend many hours practicing your advocacy skills, is named for Mr. Laird, and we are very thankful that we have him as a friend of our school. Mr. Laird received his undergraduate degree from Texas Tech University in 1976 in business. He has an MBA from TCU in 1977 and his law degree from South Texas in 1980. He is a distinguished fellow of the College of Trial Lawyers in Texas, who are board certified in 3 specific areas of practice, signifying high levels of education and experience in law. He is specifically board certified in personal injury trial law and civil trial law as well by the Texas Board of Legal Specialization. He has likewise received national certification in civil trial law from the National Board of Trial Advocacy. He is often recognized by several other individuals in the community and by outside organizations for experience in the practice of law, and that recognition began early in his career. The Texas Young Lawyers Association selected him as the Outstanding Young Lawyer of Texas in 1988. From more than 20,000 lawyers under 35 years of age practicing at that time. He was also selected as the Outstanding Young Lawyer of Tarrant County that same year. Mr. Laird has been voted as one of the top 100 Texas super lawyers and featured in Texas Monthly. He has been selected as Attorney of Influence by his peers and is published in the Fort Worth Business Press and recognized by the legal community and the county as the top personal injury attorney and top medical malpractice attorney in Tarrant County. So needless to say, we were very lucky to have him with us. I've gotten the chance to interact with Mr. Laird at the Mahon Inn of Court, of which he was the past president. And so without further ado, to present a very important topic to future trial attorneys and to future advocates in general, Mr. Steven Laird.
Thank you, John. I'm not sure that I can do much better after that introduction. Perhaps everything is going to go downhill from here. Can everybody hear me? Do I need a microphone? Is this better? Is that too loud? No? I'll go ahead and use this for a little while. But since we're going to be talking about Voir Dire this morning, I'd almost rather not use a microphone, because in court, unless you're behind a podium, in some courts you're going to have to be, if you're allowed to get outside the well of the podium, as it's called, then you're going to be without a microphone, and you're going to be addressing a group of panel members, much like you were sitting here today in this auditorium. So, if you can hear me okay, can you hear me okay?
Yes, sir.
I'd rather dispense with the microphone, if that's okay. And visit with you a little bit about what is becoming a time-honored, required part of the trial that is quickly being lost. And I emphasize that to you because in the time that I have been practicing, during the last 32 years, I have actually seen an enormous change in addressing panel members, the Bannerman, picking a jury, Voir Dire. It's handled different ways with different courts. Different judges have different rules. But overall, the process has changed dramatically. It's part of a much larger change that you're probably aware of, and that is the fact that jury trials themselves are decreasing at an incredible rate. If you look at the statistics, starting with federal court, it is amazing. Average number of civil jury trials tried per year in a federal district court. How many do you think? Average number, federal district court, civil, not criminal, civil jury trials. Anybody want to hazard a guess? Average number, 12 months. 25? Another number? Anybody?
100. A million?
A million.
You mean in the whole country?
No,
Oh,
per
just
court.
Sorry.
Per court. 25, one more number.
Grand sounded good.
Any- 1,000.
Okay. 12.
Both of you are very, very close. It's 2. 2. 2010 survey of 4 of the 5 largest urban areas in Texas. Tarrant County was the only county that did not participate. It's one of the top 5, so 4 of the top 5 urban counties participated in the survey. Harris County is the largest county in the state. How many jury trials, civil jury trials, not criminal, how many civil jury trials do you think Harris County, the most vastly populated county in our state, had as an average number of civil jury trials on a 12-month annual basis?
500?
500? 5. You're closer. 12. 1 a month. Think how big Harris County is.
That's Houston.
That's Houston. That's right. Bexar County, San Antonio, 3. Dallas County, next door, 5. These are scary statistics. I begin our visit this morning by telling you that I'm truly concerned because the nature of what we generally call trial practice is changing at such a rapid rate. And the reality is that even members of the bar are standing by and really not doing anything about it. The train has already left the station. As a general thesis, our system of justice in the United States is moving at an incredibly fast pace toward an administrative system of justice much more akin to what Europe has. So, yes, this does have to do something with Voir Dire because we're talking about trials in general. And the first part of the trial is jury selection. And if you don't have trials, you're not going to be able to get the experience of picking juries. And regardless of how many articles you read, regardless how many people you listen to, there's nothing like experiencing it yourself. And there were types of cases that lawyers like me, who started practice what seems an eternity ago, could cut their teeth on. Smaller cases, car wreck cases. We had workers' compensation jury trials. We were one of only 3 states in the entire country that allowed trial by jury in workers' compensation cases. In civil cases, those were the predominantly type of cases that young lawyers went to trial on a lot. That's not the situation now. First of all, we don't even have trial by jury in workers' compensation cases. That was taken away as of January 1st, 1991. And car wreck cases, and I'm using that term generally, are not tried like they used to be for a lot of different reasons that we don't have time to go into right now. So, the bottom line is that there are fewer and fewer and fewer jury trials being tried all the time. People like you who will be getting licensed in a relatively short period of time are going to be coming into a different legal world. And it really does concern me, as I said at the very beginning. So with that out of the way, even though I have this ongoing concern, the reality is that Voir Dire, I think, is one of the most important parts of the trial. Some people might say the most important part, and they might come in and say, oh yes, but cross-examination, you know, you've got to do well on cross-examination. Or direct examination, you've got the burden of proof if you're the plaintiff, and if you're the defendant, you've got to be able to come in and cross-examine after a good direct, so direct examination has to be very, very good. Well, what about opening statement? You've got to connect with the jury on opening statement. Because studies have shown that by the time opening statement ends, after voir dire and then opening statement, 80% of individuals have tentatively made up their mind on the outcome of the case. 80% have tentatively made up their mind. Most of that 80% will not change their mind. There's a small percentage that still will be susceptible of being changed. So think of it in those terms. These are studies that have shown time and time again that the beginning of this process, that includes voir dire, is ever so critical. Voir dire, as I indicated, is going to be conducted under different rules in different courts. We have 2 federal district judges here in Fort Worth. And as far as voir dire is concerned, they're typical of the way most federal judges allow voir dire to be conducted. In federal court, if you have a civil case, most federal district judges will give you, after they ask questions that they want to ask, some of which may include written questions that you have submitted to the court. Federal district court judges will give you between 5 and 10 minutes for voir dire each side. Judges here, 5. I can remember trying a products liability case up in Sherman, Federal District Court, a number of years ago. 7 lawyers were on the other side. It was somewhat of a novel case. It involved the lack of deployment, the failure to deploy of an airbag. And it was one of the first airbag cases tried in the entire United States. Older federal district judge. And I can remember sitting in a semicircle with the 7 lawyers on the other side in his chambers before trial. It was during the pretrial conference. And I had filed a motion, because in federal district court, you have to file a written motion on anything. I had filed a motion requesting additional time, outlining my reasoning, my arguments. The judge looked at me over his glasses, and at that time he was probably close to 70. He said, "Mr. Laird, I have read your motion, and I understand that this involves some novel arguments and areas of law, and this is a unique type of case because it's one of the first types of these types of product liability cases tried in the entire country. But you understand that I have a rule in my court about only allowing 5 minutes of voir dire." "Yes, Your Honor, I do." "Mr. Laird, after reading your motion, I sympathize with you. I tend to agree with you. But I will tell you, against my better judgment, I decided to grant your motion. So therefore, I'm going to give you an extra 5 minutes." And then he followed it up with a statement that I'll always remember. "But don't argue your case." Actually, that was probably the most profound statement that he made. Because something else that has changed with voir dire, with the diminishing jury trial, and the lack of experience that you're going to get to do jury trials overall, especially voir dire, is the fact that the way voir dire is conducted has changed significantly. For decades and decades and decades, lawyers, young lawyers, would learn from older, more experienced lawyers. And the approach to voir dire was probably 80 to 85% argument in voir dire with the way you asked the venirement, the panel members, questions. And 15 to 20%, maybe, was spent trying to identify jurors that would be either good or bad for you. But it was primarily a convincing and argumentative, although subtle, approach to jury selection. That truly was the way that Voir Dire was conducted. Too many decades for me to know about, probably going back who knows how long. And then come the late 80s and early 90s. Studies were done. Focus groups were done. And lo and behold, it was seen that that's not the way to effectively conduct Voir Dire. And if you think about it for a moment, we'll go through the process. Regardless of how much of a smoking document you think you have, and admission of somebody on the other side, whether you're plaintiff or defendant, that you think will absolutely just smoke the other side. You're going to crucify that witness. You cannot wait. Regardless of what type of argument you think you're going to be able to fashion, remember, every piece of evidence, written and spoken, is going to come through a filtering process. And that filtering process are the eyes and the life experiences of 12 people sitting on the jury. Everybody walks in the courtroom with their own life experiences. And to a large extent, some lawyers still try to stereotype individuals who come in and they see on the panel. Minority, oh, they're going to be a better plaintiff's jury in a court case. Or someone who is an engineer is going to be extremely conservative. Somebody who is a CPA or some type of financial background is going to be very critical of damages regardless of what type of case. Those are general stereotypes. And 90% of those stereotypes you should not bring into the courtroom with you. You should not fall into that trap that so many lawyers have fallen into. The filtering process are through the life experiences of those 12 individuals. And I can assure you, because I've seen it way too many times, when they get back into the jury room, one juror may talk about her Aunt Susie, who had a certain type of experience. Aunt Susie never testified. None of the lawyers know about Aunt Susie. And so there was no cross-examination, certainly no questioning during voir dire about Aunt Susie, but yet Aunt Susie might become a very vital part of the trial. And you won't even know it. And believe me, there will be a lot of Aunt Susies in your trials. So you've got to do now something that's very different, and that is take the approach, almost the singular approach, that your mission, the purpose of voir dire, is to identify potentially bad jurors for your particular case, whether you're plaintiff or defendant. As far as convincing somebody, if you have any questions that are put in a fashion that are meant to subtly convey information and persuade during voir dire, you need to keep it to no more than 10%. Because to a large extent, 90% of your effort should be identifying jurors who are not going to identify with your client, plaintiff or defense, your particular position in the case, plaintiff or defense. Whether it's a contract case, an oil and gas case, a tort case, doesn't matter. The purpose of voir dire should be the identification of those individuals who you are going to have great difficulty persuading because of their background, their life experiences, and their biases and prejudices. Bias and prejudice, two words that you've probably heard about if you've read any cases on voir dire, with the legal meaning a little bit different than the street meaning that most people think about when they hear those terms. The vast majority of people, when you ask them about bias and prejudice, what do you think they most people immediately think of? Racial bias and prejudice. And obviously, we're talking about much, much broader legal term of art when we're talking about bias and prejudice. So let's talk about the very beginning of Voir Dire. After you found out what the rules are of the particular judge involved, how much time is the judge going to allow? Is the judge going to require you to stand behind the podium and asking all of your questions? A lot of them do. I don't like that. For the courts that have required that, I still, to the extent that I can, step out whatever I can. And I've been told a number of times, Mr. Laird, please get back inside the well. That means the well, the podium. But I don't like to have a barrier between me and people I'm trying to communicate with. You know, and how many of us do? I mean, when we're having normal conversation, how many of us want something in between us? No, we don't. It's not natural. But yet, here we are. To begin with, you're going to have a bar between you and these panel members, at the very least. Even if you're allowed the entire courtroom. And if you are allowed the entire courtroom, take advantage of it. Whether you're behind the podium or out from it, the court will either read the style of the case, the court may or may not give a brief description of the claims. A lot of courts will just say, this is a breach of contract case, or this is a automobile collision case, or whatever it might be. And counsel, are you ready? Addressing both plaintiff and defense counsel. Mr. Laird, you may proceed. Then the plaintiff's lawyer will get up, and there's no particular rule, not written in black and white, whether you introduce your client first or say something to get their attention first. You might want to say something, but don't waste time. Don't worry about going into a lot of pleasantries. Don't worry about taking a lot of time to thank everyone. I've done that in the past. I don't do it now. Primarily because more and more judges condense the time. A lot of judges now will give you 30 minutes in state court. Some don't have a restriction on voir dire. Here we have 10 civil district judges in Tarrant County. Some of them will give you as much time as you want, within reason. Some of them have a 30-minute restriction. So you've got to gauge what you say in connection with how much time you've got to be given, you're going to be given. Keep in mind that when you're talking to a group of people, you're going to look at them collectively initially. Before you even stand up, you're going to be given juror information cards. The juror information cards are going to have very limited information on them. Name, address, occupation, spouse's occupation. It's going to have religious affiliation, political affiliation or preference. Whether anybody is, in their immediate family is involved in law enforcement. Have they been convicted of a criminal offense? And that's about it. So you have very limited information and sometimes extremely limited period of time to read those jury information cards. And I've been in trials where the clerk would bring over the jury information files, and usually in state district court, most of the civil trials are going to have 36 panel members. If you've got a complex case, it's going to take quite a while, any type of novel issues or issues that are going to potentially disqualify a lot of people because of their biases and prejudices. Example, you sue the only practicing physician in a rural county. You might want a larger jury panel. You have to ask for that in advance. But I've been in trials where the clerk has brought over the 36 juror information cards, and I get them, and I'm on like the second one, and the judge says, is everyone ready? It's not a very good position to be in, but it happens. So with any luck at all, you may want to call the Friday before and at least find out, when are the jury information cards going to be ready? When can I pick them up? You may be told Monday morning when you come to court, but at least call. You look at the jury information cards, and then you visualize the panel. Before voir dire starts, before you make the decision whether you're going to introduce your client or you're going to make a sentence, say a sentence of some sort first, the very first decision you have to make, and it's one that only a Texas lawyer can make, because we are the only state in the United States that allows this to happen in state court. And that is to determine whether you need to request a jury shuffle. A jury shuffle is allowed under the rules of civil procedure, and there's an effort underway right now to eliminate that. Who knows, in the next legislative session, where the legislature meets from January through May every other year, which will be next year, 2013, it may eliminate the jury shuffle. If you wish to ask for a jury shuffle, because, let's just take an example. Let's say that it's a situation where the first 8 out of 10 panel members are the same profession. Actually, there was a case. It came from Tarrant County. 7 of the first 10 were teachers. The plaintiff's lawyer didn't like that. And there was a question about jury shuffle in that case. What happens in a jury shuffle is that you have to make the decision before voir dire starts. And you simply ask the judge, may I have a shuffle, judge? And then depending upon the county, they'll either put them in a rotating basket, cylinder, or they'll shuffle them up, but they'll put the same panel, the very same 36 people or 40 people, whatever number, in a different order. Now, why is that important? Because you don't pick a jury in Texas. It is a misnomer. Nobody picks a jury because it's a deselection process. The first 12 people left over after peremptory challenges are exercised and panel members are disqualified for legal reasons, the first 12 people left over go to the jury box. So you're not picking individuals, you're deselecting individuals, and the first 12 people left over after you take some people off through peremptory challenges or get them disqualified as a matter of law by the judge are the 12 jurors. Or if it's county court at law, it'll be 6 jurors who will end up as your jury. There's a case also out of Tarrant County, came out of the 17th District Court, that emphasized that jury shuffles need to be exercised before voir dire. And you might think, well, okay, that means before you start asking questions. Absolutely. But sometimes there are jury questionnaires. In addition to these jury information cards, the parties may get together, or one party may file a motion that's granted by the judge to allow written questions to be submitted to panel members before they come into the courtroom. The benefit of a questionnaire is to get more honest answers generally, more extensive answers. It saves time generally. It helps to get more information overall about this group than you might be able to get in 30 minutes or even an hour. That case emphasized the fact that voir dire starts when the written information, not jury cards, that doesn't count, but if it's a questionnaire over and above the basic information about panel members are received by any of the lawyers, that's the beginning of voir dire even before a question is asked. And you have to request a shuffle before you get any information from the panel, except jury cards, that doesn't count. If you get any additional information in any form from the panel, including written answers responsive to a questionnaire, that starts Voir Dire. Once Voir Dire starts, you cannot ask for a shuffle. Like I said, we're the only state in the union that has that.